want you to go take ETG, see if you've got any alcohol in your system.
All right. In essence, you're seeking an adjournment of these.
No, we're setting preliminary exam.
Exam. All right.
Hold on, just relax.
People would have their witnesses available tonight.
Tonight?
Preliminary examination in this matter will be set in person September 9th.
Judge, I'm sorry to interrupt you, but I have probate matters. I have 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Could we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
To the 8th,
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're going to go test. You're going to take that.
What I'm going to do is I'm going to order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post it in the fashion those are posted. You need to go over and take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court.
Did you catch that? The defendant is lucky here. Even though she already broke the rules by leaving the state, the judge is giving her another chance, ordering a tether and SoberLink device instead of locking her back up. This is critical. A SoberLink acts like a remote breathalyzer, sending results straight to authorities to ensure she's not drinking. It's a big deal because courts usually tighten the leash when they sense repeated disregard for orders. Yet, despite her missteps, she's still being allowed to travel. This raises a tough question for us watching at home. Is this leniency, or is the court giving her rope to hang herself? Drop your thoughts. Should the judge have revoked her bond? Right here, or is this fair?
Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed and SoberLink in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays?
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether. Anything else?
No, Your Honor. Was she supposed to report back today after the testing?
No, she doesn't need to report back today. She needs to go over and take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Mr. McClan, who's approaching. Could you say your name to the court?
Michael McCartney.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available to second?
We'll do our best, Your Honor.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her and not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Zender, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property when she would come outside.
Now here's where things get really dark. Listen to what the prosecutor just laid out. After being released, this defendant allegedly went straight to the victim's house, hid on her property, jumped out yelling accusations, and then continued to call and leave voicemails. That's classic stalking behavior, and it gets worse when you look at the criminal record. Home invasion charges, malicious destruction of property, and a pending domestic violence case. This isn't just about one mistake. This paints the picture of a long, dangerous pattern. And while the defense tries to argue technicalities about when exactly he was served with the no-contact order, the fact remains, once he knew, he still went back. The judge ultimately denies a bond reduction, and honestly, can you blame him? Be honest. If this was your neighbor, would you feel safe with him back on the street?
He jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007 and 2022 dismissed home invasion first, a 25 dismissed PDHD second, and malicious destruction of a building. And he currently does have a hold outstanding for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it
HBA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I could clarify, I'm not sure exactly until arrested. If I could clarify, he went to the residence on 5/28, was served the PPO that day, and then in the preceding days after he was served the PPO and told he should not be having contact, he went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court is this is not a hearing date, so I know we can't get into the details. The missed call log and discovery shows 5/28 and not after. So we dispute that he made any contact with her after being served the PPO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
So let's recap. Today's hearing highlighted everything from alcohol testing and bond conditions to allegations of stalking, trespassing, and a serious criminal past. The defense tried to soften the timeline, but the judge wasn't swayed. Bond stays in place, no reduction, and the defendant remains under tight supervision. This case is a prime example of how courts have to balance giving someone a chance at freedom against protecting the community from ongoing danger. What do you think? Was the judge too harsh, too lenient, or right on the money? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.